First case to come before us this morning is State of Ohio versus Ronald Diamond. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If the appellant will reserve any time for rebuttal, if you let me know when you get started on keeping track of the clock.
I would reserve 5 minutes. We're okay. Just wanted to check.
Please don't use the names of any victims or minors, as these arguments are being recorded and they will be posted on the court's YouTube channel. We've read the briefs. We're ready to proceed when you are.
Great. Good morning. May it please the court, Giovanna Bremke on behalf of Mr. Ronald Diamond. In my brief, I present one assignment of error, and that is that the court erred in sentencing Mr. Diamond to life without the possibility of parole in violation of the principles and purposes of sentencing. This is a unique set of facts in which Mr. Diamond pled guilty very early on in his case, and it was what the record describes as more or less a mercy kill. Mr. Diamond did accept responsibility for shooting his wife. She lived for a short period of time, of 21 days, before she passed away. They were both an elderly couple. Both were medically challenged. He was in a car accident and had been prescribed increasing amounts of pain medication. And I say that not for the purposes of showing that he had any sort of addiction, but that the severity of his medical condition and that he was the primary caregiver for his wife, who had severe medical challenges. She had an autoimmune disorder. I'm not even going to try to say the name of the disease, but the record does reflect that she's only 1 in 6 individuals with this disease. It left her with no muscles in her face, and simply the weight of her skin crushing on her nerves was an insane amount of pain. She took pain medications. Her son testified at, or made a statement at sentencing that she took pain medications for 70 years, and that the couple had moved specifically to Ohio to get her the medical attention that she needed, because again, as 1 in 6 people with this condition, she was able to get medical attention here. And Mr. Diamond actually had a very successful career before ultimately they moved here to Ohio. She had to have all of her teeth removed. She had stainless steel plates in her face, surgeries that tied her eyelids shut. She couldn't swallow and only weighed 70 pounds. She would sleep for 20 hours a day and only wake up to receive pain medications. And nearing her death, her pain condition worsened. And what's significant is that the record reflects that the police indicated that her last words were, "I love Ron and Ron loves me." All of this to say that the principles and purposes of sentencing, and I went through them in my brief and sort of weighed the more serious and less serious factors, would not amount to a sentence of life without the possibility of parole. This is a very unique situation in which, in one of the, and I'll get to that, but one of the less serious factors would be any mitigating, and there's a large amount of mitigating factors in this case. When you're looking at those factors that the court must weigh, the not more serious factors, that recidivism is unlikely, the record reflects that sentencing, Mr. Diamond had not received even so much as a traffic ticket in his lifetime. He had not had any criminal history at all in any sense.
Recent investigation in this case?
I don't believe that there was.
So when you say the record, would just be the comments at sentencing that we'll be looking at for the record?
Correct, but neither party disputed that. I think the discovery in the case that both parties received reflected that, and I believe there may even be a indication from the state that they weren't able to find any sort of criminal history.
I want to make sure there was no PSI, and I understood the record properly. Thank you.
No, I don't believe so. And that, again, that he had no criminal history, and the only person to speak at the sentencing other than Mr. Diamond and the attorneys was the son of both Mr. and Mrs. Diamond, who wasn't advocating for life without parole and was fairly sympathetic to both sides of the situation. One of the factors is the physical damage, and this is a difficult one to argue, but because of the severe amount of pain that Mrs. Diamond experienced, there was in the record a large amount of indication that this pain that she experienced as a result of this was not, that there was a question about whether she could feel the physical pain, and also psychologically, the damage would, it'd be clear that she was not psychologically damaged because she indicated that she did love Ron and he loved her. When you're looking at the less serious factors, that it was induced or facilitated by the victim, and again, this is a unique set of facts, I don't think this is how we usually see this factor applied, but there was also on the record in the sentencing that Mrs. Diamond had executed documents allowing her life to be discontinued if medically necessary, and that she had indicated that to Mr. Diamond. He had said that they had conversations that if my health gets this severe, please discontinue my life. So she did instruct him in that, the record is clear of that. It's also Revised Code 292912C, which allows for the mitigating factors. And again, this is one of the most compelling cases for mitigating factors. This is a gentleman who has no criminal history. He was essentially, it was an assisted suicide, and he was carrying out the wishes of his medically challenged wife, while also suffering from the consequences of him being a caregiver with his own medically challenged issues. So again, the sole assignment of error is that he shouldn't ever receive life without the possibility of parole, because the sentencing factors just don't equate to that sentence.
If we were going to resentence at this level, what would you be requesting for sentence?
Well, I think that the only possibility is life, with the possibility of parole. If there's no questions, I'll reserve the rest of my time.
Thank you, counsel, you'll have your full 5 minutes of rebuttal.
Good morning, Your Honors. May it please the Court. Lindsay Popark, Lorain County Prosecutor's Office, on behalf of the state. Ronald Diamond shot and killed his wife of 38 years in what was intended to be a murder-suicide. But Diamond didn't follow through on his end of the plan. Rather, when his wife started yelling out in pain, he called 911 to advise that he botched the plan. Diamond pled no contest to a 6-count indictment, including a charge of aggravated murder, thereby stipulating to the truth of the facts outlined in the plea. As set forth in the plea, Diamond's wife was alive at the time the law enforcement arrived at their home and was suffering from gunshot wounds to the chest. She ultimately died 21 days later as a result of her injuries, having been placed in the ICU and later in hospice. Suicide notes were strewn about the house, showing that Diamond had planned his act. At the time of the plea, Diamond was advised that the maximum penalty that could be imposed for aggravated murder was life with the possibility of parole after 20, 25, or 30 years, or life without the possibility of parole. Diamond acknowledged his understanding of the penalties. Ultimately, Diamond's plea was accepted. Diamond waived a PSI report, and at his request, the matter proceeded directly to sentencing, the trial court having no benefit of a PSI. The trial court ultimately sentenced Diamond to a life without the possibility of parole. Now, Diamond contends that his sentence is in violation of the overriding principles and purposes of sentencing contained in the Revised Code, and cites to RC 2953.08G2 to support this court's ability to review the propriety of his sentence. Now, I inherited this appeal from a former colleague, and I would like to make mention of a provision in the statute that Ronald Diamond cites that may affect this court's ability to review the appeal at the outset. This statutory provision was not cited in our brief, But under D3 of the statute, a sentence for aggravated murder is not subject to review typically on appeal. So I'd just like to flag that for the court, and to the extent that that may affect this court's ability to review the appeal, I would just like to make note of that. Nevertheless, if Diamond's appeal is properly before the court, he still faces a large hurdle, as he can only obtain the reversal of this the trial court's sentencing decision if he shows by clear and convincing evidence that the sentence was not supported by the record or was contrary to law. Here, the trial court sentenced Diamond to a life prison term without the possibility of parole based on the seriousness of his conduct and the irreversible damage that it caused the victim. And a trial court has full discretion to impose a term of prison within the statutory range and is not required to make findings or give its reason for imposing more than the minimum sentence. And although the court must consider the sentencing factors when the statutory sentencing factors, it does not necessarily need to state its reasons for those factors on the record. But Diamond has failed to demonstrate by clear and convincing evidence that the trial court sentence, which falls within the statutory range for aggravated murder, is unsupported by the record of the sentencing guidelines. At the sentencing hearing, the trial court explained that the circumstances of the murder indicated that Diamond decided to self-appoint yourself as an executioner, and that he crossed the line into a point that we cannot tolerate in this society. Clearly then, the court considered the seriousness of Diamond's conduct, the need to deter others, and punish Diamond. The trial court also learned at sentencing that after the shooting, the victim lived for another 21 days in the intensive care unit and then hospice care. The court was mindful of the harm that the victim suffered when imposing his sentence. The trial court noted at sentencing as well that it had considered all of the sentencing factors in the revised code and was without the benefit of a PSI report to further contemplate additional information. Based on the totality of those circumstances, the state would submit that the sentence was appropriate and not contrary to law.
And you are aware, counsel, if the reviewability of this was not argued in the briefs, then it's not going to be.
Correct, I just wanted to
I understand.
flag that issue. Thank you.
Thank you, counsel.
I wanted to clarify a few things, but Judge Hensel kind of already touched on one of mine. Again, I'm getting passionate to the fact that my colleague had inherited this case, but I don't think it's appropriate to review new arguments on an oral argument. I also agree that the court doesn't have to make findings. I think the law supports that, but the record has to support the sentence, and I think it's clear in this case. It just doesn't. It's a unique situation in which, again, the factors just are not supported by the record in any way. So we would ask that you reverse or correct the sentence. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement. We will issue a written decision in due course, which will be mailed to all parties to this appeal by the clerk of courts, as well as be posted on the House Supreme Court website. Thank you both again.